Commissioner is for Her Majesty's Revenue and Customs.
Mr. Swift.
My Lord, good morning. I appear for the Commissioners in this appeal, together with Mr. Andrew McNabb, Mr. Peter Mantle and Mr. Imran Afzal. My learned friends, Mr. Rabinovich, Clean Counsel, Mr. Elliott, Mr. Jones and Mr. Slaughter appear for Littlewoods. My Lord, if I can, in a few minutes, just identify the order in which I'll take matters. First, I will attempt a brief, and I underline the word brief, introductory sketch of the issues that have led to this litigation. Then I will deal with the issues in the appeal. My Lord, you will have noticed that the issues retained the numbering that they had before Mr. Justice Henderson, the Court of Appeal, which I hope will ease reference back through the previous judgments in this case. Firstly, I'll address issue 2, which is the EU law interest issue on the meaning of the judgment of the Court of Justice on the reference made in these proceedings, as to the scope of the EU law obligation to pay interest where tax has been paid contrary to the requirements of EU law, and also whether the provisions for repayment of overpaid VAT and payment of statutory interest in sections 78 and 80 of the VAT Act are consistent with that overall EU law obligation. And again, that's the obligation that's come to be referred to as the San Giorgio obligation.
Yes.
Then I will go to issue 3B, the so-called selective disapplication point. The matter here, my Lord, is that if section 78 and section 80 are not consistent with the San Giorgio obligation, should the prohibition within them against common law claims be disapplied to the extent of permitting any common law claim to be pursued, or only to the extent of allowing the pursuit of common law claims that share the characteristics of the San Giorgio obligation. My Lord, the point here is that liability on a woolage-type restitution claim depends only on the fact that tax has been paid when it was not lawfully due, whereas liability on a mistake-based restitution claim obviously depends on the presence of a relevant and operative mistake. My Lord, then I will deal with issue 6A, which is the English law issue as to the restitution measure of recovery, whether that is an objective measure, equivalent to compound interest in this case, or whether the measure of recovery is the value of the actual benefit obtained by Her Majesty's government. And then finally, in terms of opening, I'll deal with issue 6B. The matter here is that if issue 6A is answered in favour of the Commissioners, does EU law require the court to modify the restitution measure of recovery to meet the requirements of the San Giorgio obligation, or is some other course of action available? My Lord, that will leave issue 1 and issue 3A. Issue 1 is the matter raised by Littlewoods on their cross-appeal as to the effect of sections 78 and 80 of the VAT Act, yes, and whether they prevent the common law claims that Littlewoods pursue in these proceedings. To date, all judges who have considered this litigation have concluded that the answer to this question is yes, that there is a prohibition. And it's that conclusion, obviously, that is the starting point for attention to EU law rights. Issue 3A is closely linked with issue 1. Issue 3A is Littlewood's contention that as a matter of construction, in accordance with the Mar-leasing principle, sections 78 and 80 of the VAT Act can be read consistently with the EU law San Giorgio obligation, thus avoiding any question of disapplication. The arguments on issue 3A follow very closely behind the argument on issue 1. And, my Lord, for that reason, my intention is not to address either of those matters in opening, but instead...
Can I stop you there a second?
Of course, yes.
We see some force at the moment, and only I say some force, we haven't reached a conclusion on this, in hearing you and Mr. Rabinovich on issue 1 and issue 3, and then seeing where we've got to, but taking those two issues together before we embark on the other issues. It's right to mention that because in the way you've described things, we may find, or you and Mr. Rabinowitz may find, that we stop you after issue 3 and call on Mr. Rabinowitz on issue 1 and 2. No, I think it's issue 1 and 3, isn't it?
Issue 1 and 3A would be
Yes.
the ones that went together on.
Well, no, I think, sorry, did I say, yes, it's issue 1 and issue 2. Are the two, sorry, I said issue 1 and issue 3. Issue 1 and issue 2 seem to us to be ones which we would like to hear, as it were, on their own, or might like to hear on their own. You're proposing to develop issue 1 and issue 2.
Indeed, my lord,
Well,
yes.
I think then how we'll leave it is that we will, when you've developed issue 1 and issue 2, we will consider where we got to.
Right.
And at least raise the possibility of hearing Mr. Rabinowitz on those 2 issues before we turn to the other issues.
Very well, my lord. In that case, then, I'll as promised or threatened, I'll do the brief sketch of the circumstances. Then I think probably logically go to issue 1 and then issue 2, although if you'd like to hear them in reverse order, I'm content to do it that way.
Well, if you've prepared them in a different order, as far as I'm concerned, that's fine, whichever order you want to take them in. But it seemed to us that it might be a sensible way to proceed.
Very
But
well.
we'll hear you on them and then decide. But it's I don't want to take Mr. Rabinowitz by surprise.
Would the logic of your position be that you'd want to address us on issue 3A with issue 1,
Yeah.
then go on to issue 2?
Well, issue 3A tucks in behind issue 1
That's the
in a
point.
way, because each is ultimately a construction issue, albeit issue 3A has the Marleasing
Yeah.
construction point put into it.
Yes, because you don't get into issue 2 unless HMRC succeeds on issues 1 and 3A.
Well, if I succeed on issue 1, then one goes to issue 2.
Yes.
If I fail on issue 2, then one goes to issue 3A and 3B.
Right.
Oh, sorry, yes, okay.
I mean, maybe not now, maybe not right now, particularly as your first time it's been raised, but it seems that issue 1 and 2 could be taken as an issue, as a combination of issues which you and Mr. Rabinowitz could deal with before we turn to the other issues.
Very well.
Is that right?
Yes, I'm content to take it in that way, my lord. Yes. Right. Well, first then, by way of introduction to the litigation, as the court will be aware, this litigation has followed from overpayments of VAT made by the Littlewoods companies between 1973 and 2004. The circumstances in which those overpayments came to be made are summarised both in the statement of facts and issues and in the judgment of Mr. Justice Henderson. Well, if I could just give you the reference for that rather than take you to it, it's volume 9, tab 77, and it's the passage between paragraphs 31 and 62, which is MS 3000 to MS 3007. But I don't invite you to go to that now, but by way of summary of that, the overpayments of VAT arose from the treatment for VAT purposes of commission earned by Littlewoods sales agents when they made sales referred to as third-party purchases.
Yes.
Whether the VAT treatment of those commissions was correct first arose in 1997, and the question then concerned only one aspect of the commission arrangements. That issue was the subject of litigation which went to the Court of Appeal in October 2001, and the Court of Appeal decided in favour of Littlewoods. The reasoning of the Court of Appeal in its judgment on that occasion prompted Littlewoods to raise further overpayment claims which related to other aspects of the commission arrangements relating to the third-party purchases. Those claims were they were raised by Littlewoods in 2002 and were ultimately conceded by the commissioners. The overpayment claims were initially in respect of a period of 3 years prior to 2002, as permitted by the limitation provisions that had been inserted into the VAT legislation between 1996 and 1997. But following the judgment of the Court of Justice in the Marks and Spencer case, which declared those amendments to the limitation periods to be unlawful, as they had failed to include sufficient transitional provision, Littlewoods claims for these purposes came to stretch back to 1973. The overpaid VAT was repaid by the commissioners between 2005 and 2008. And the sum that was repaid was £204,774,736. Over the same period, the commissioners also paid statutory interest on the overpayments, and that interest came to £268,159,135. My Lord, may I take you to the two provisions in the VAT Act, Section 80 and then Section 78. They're both in Volume 1 of the authorities, and firstly Section 80, which is behind tab 18. And, my Lord, behind that tab, the court has copies of two versions of Section 80. The first you'll see at 933 is the version that was in force between 2005 and 2008. Could I invite you to go to the second version, which starts at page 939?
Yes.
And it's the version that was in force between 1997 and 2005.
Yes, so we see, yep.
So, subsection 1.
Yep.
One sees there the liability of the commissioners to repay VAT that was, or sums that were paid as VAT when VAT was not in fact due.
Yep.
And then over the page, my Lord, over 2 pages, in fact, to 941, subsection 7, except as provided by this section, the commissioners shall not be liable to repay an amount paid to them by way of VAT by virtue of the fact it was not VAT due to them.
Yep.
So an exclusive route for repayment by the commissioners provided by Section 80, so far as principle is concerned. Then, my Lord, tab 17.
17.
17, my Lord, yes, Section 78.
Thank you.
And again, there are two versions there. The first, starting at 921, is the version in force between 2005 and 2009. If you could go to page 927, my Lord.
Yes, of course.
This is the version in force between 97 and 2005. Firstly, Section 78, subsection 1.
Yep.
1A, where due to an error on the part of the commissioners, a person has A, accounted to them for an amount by way of output tax which was not output tax due from him, and which they are in consequence liable to repay to him. And then I'll read the tail piece of this subsection. Then, if and to the extent they would not be liable to do so apart from this section, they shall pay interest to him on that amount for the applicable period, but subject to the following provisions of this section. Then, my Lord, subsection 3, on the next page, interest under this section to be payable at the rate applicable under section 197 of the Finance Act 1996. And then subsection 4 identifies the applicable period for a case falling within subsection 1A, and effectively the period for which interest is due from the date of payment to the commissioners to the date where the authorisation of the Section 80 repayment is made by the commissioners. So the period of interest covers from date of overpayment to date of repayment. My Lord, for your note, Section 197 of the Finance Act 1996 is in tab 8 in Volume 1 at MS 822. I don't ask you to look that up. That section contains a power for the Treasury to make regulations specifying the rate of interest that is payable in relation to various statutory provisions.
Yes, I see it.
The relevant regulations are in Volume 2, my Lord. If I could ask you to look at those.
Which tab?
Volume 2, tab 23.
Page 996,
996, my Lord.
Yep.
And if I could invite you to go first to Regulation 5 on page 1000. Regulation 5, and you'll see that 5.1c refers to Section 78 of the 1994 VAT Act. Regulation 5 sets out the rate of interest prospectively. regulations, and so one has there a formula by which the interest payable is to be identified. Then, if you turn the page to page 1002,
Yep.
Regulation 8 has a series of tables that sets out the rates that are payable historically in relation to various taxes. My Lord, Table 7 is the table that applies to Section 78 of the VAT Act.
Yes, I see.
And you see there interest rates commencing from the 1st of April 1973 and going through to and including July 1998, which was the date on which the regulations that you see came into force. So one has the regulations there providing a scheme both prospective and historic in relation to the interest that is payable. My Lord, in these proceedings, Littlewoods have made mistake-based restitution claims, and in legal terms, the starting point for those claims is the overpayment of VAT. But what Littlewoods has always sought by way of relief is to recover the difference between the statutory interest that has already been paid and compound interest on overpaid VAT. My Lord, the trial of these proceedings, as the Court will know, took place in two parts, separated by a reference to the Court of Justice. At the second part of the trial, which was conducted before Mr. Justice Henderson, the judge heard expert evidence on quantum, and if I may, I'll take you to his findings on quantum at this stage, just so that you have an idea of the shape of the arguments, or at least the extent of the arguments when it comes to the measure of recovery. My Lord, Mr. Justice Henderson's judgment is in Authorities Volume 9 at tab 77. The report starts at page 2980. Could I ask you to go to page 3110, please, my Lord?
Yes, you can. Yep.
And I hope there you will find a heading just above paragraph 376, expert evidence of Professor Kay and Dr. Richardson. Professor Kay was the expert called by Littlewoods, Dr. Richardson the expert called by the commissioners. Summarising the section that follows, the first point is that Mr. Justice Henderson accepted the evidence of Professor Kay for Littlewoods as to the valuation of the time value of the overpaid VAT. That's the passage between paragraph 377 and 379. And Professor Kay's valuation of the time value was £1,246,073,880.
Where do we see that?
That figure you see right at the very end of the passage, my Lord. If you go to... Sorry. Sorry, I was going to take you to a paragraph that had different figures in it in relation to Dr. Richardson's evidence.
Are we concerned with the detail of this?
Only to the extent of understanding the shape of the positions of each party, but there's no dispute as to Professor Kay's figure in relation to...
That's not challenged before us.
It's not, no. That dispute was determined by Mr. Justice Henderson and has not been decided, as indeed when it comes to Dr. Richardson's evidence, to the extent that his evidence has impact. Again, there's no dispute as to the findings of fact that Mr. Justice Henderson made. But the Professor Kay figure was Mr. Justice Henderson's conclusion as to the value of the time value of the overpaid VAT, and he also concluded that that measure, the time value, was the correct measure of restitution recovery, rejecting the Commissioner's argument that actual benefit should be the measure of recovery. But to guard against the possibility that a different court might disagree with his conclusion on the measure of restitution, Mr. Justice Henderson also made findings of fact as to the actual benefit. My Lord, he begins addressing that issue from paragraph 385, page 3113. On this point, ultimately, Mr. Justice Henderson preferred the evidence of Dr. Richardson. If I could take you very quickly through the passage in the judgment, you will see at paragraph 389 on 3114 and 390 on the further page, Mr. Justice Henderson there sets out certain passages within Dr. Richardson's evidence as to whether, in fact, the overpaid VAT was directed each year to reduction of government borrowing. His conclusion at 396 to 397 on page 3118, you'll see there from 396, on this part of the case, I prefer the approach and reasoning of Dr. Richardson, and Mr. Justice Henderson then explains why. 397, he addresses Professor Kay's evidence on the actual benefit argument. And then at paragraph 405, over the page at 3120, the conclusion by reference to Dr. Richardson's evidence, Dr. Richardson's first approach, which is broadly equivalent to payment of simple interest on the overpaid sums, yields, according to his revised calculation and up to his chosen calculation date, a total benefit derived by the government from the overpayments of 338 million and following, which after deduction of the statutory interest already paid leaves a net amount of £70,656,449. And then Mr. Justice Henderson went on to deal with Dr. Richardson's alternative approach, which produced a slightly larger amount. That alternative approach is described by Mr. Justice Henderson at paragraph 404. I don't need to trouble you with that for present purposes. But, my Lord, you'll see from that the scope of the difference between the parties. In terms of measure of recovery, if the correct measure of recovery is the time value of money, then the figure identified by Mr. Justice Henderson is the 1.2 billion figure on the basis of Professor Kay's evidence. If, however, the measure of recovery is equivalent to the actual benefit obtained by Her Majesty's government, on that basis, the starting point is Dr. Richardson's first approach, which is 338 million or so, which then, once the statutory interest is paid, is taken into account, produces a net figure of 70 million and following. So, my Lord, that is a very brief sketch of the background to the litigation and the scope of the practical issue between the parties in that litigation. My Lord...
and where is the most concise statement of the reason for preferring the first method rather than the second method?
It is paragraphs 402 and 403, my Lord.
Thank you.
Good.
My Lord, that was all I intended to say by way of introduction. May I now turn to issue 1?
Yes.
Now, Lord, if I could ask the Court to have to hand the Commissioner's supplementary skeleton, which is tab 11 of the core volume. This is a skeleton that deals with the response to the cross-appeal and with sections 78 and 80.
Yes.
My Lord, you'll see from paragraph 2 of that document that the Commissioner's submission is that there are two matters of significance, or at least two matters of initial significance in relation to issue 1. The first is section 80, and in particular section 80 subsection 7 of the VAT Act, which, as set out at paragraph 2, and you've seen in the volume of authorities, provides a prohibition that, except as provided by section 80, the Commissioners are not liable to credit or repay any amount accounted to them by way of VAT that was not due to them. The second point is within section 78 of the VAT Act, and my Lord, again, you've seen that. That was tab 17,
Yes.
and it is the what's been described in the skeleton arguments as the section 78.1 reservation. It's the words that follow the subparagraphs in section 78.1. If and to the extent they would not be liable to do so apart from this section, they shall pay interest to him on that amount for the applicable period, but subject to the following provisions of this section. Section 78, as you have seen, imposes an obligation on the commissioners to pay interest on overpaid VAT. And like Section 80, Section 78 is also prescriptive. It prescribes the circumstances in which interest is to be paid. It also prescribes how the interest paid is to be calculated. In that sense, establishes a coherent scheme for the payment of interest. The effect of those two provisions has been considered by each of the judges who has had involvement with this case. My Lord, Mr. Justice Voss considered this issue in the first part of the trial in these proceedings, and my Lord, you see the reference to that at footnote 5 to the Skeleton argument. And let me just give you the reference to that in the... Oops. Yes, it's volume 9, tab 77, my Lord. Volume 8, tab 76. Similarly, Mr. Justice Henderson, in different litigation, Chalk and commissioners considered the same point because the same Section 78 and Section 80 issue arose. And again, the Court of Appeal obviously considered that in this case. My Lord, we also place some reliance on the observations made by this court in the investment trust companies litigation. That case did not concern, obviously, precisely the same issue as to Section 78 and Section 80 as arises in this appeal. Nevertheless, in relation to Section 80, and the question in that case as to whether that left room for effectively a third party to seek repayment of principal, repayment of overpaid VAT, this court was clear in describing Section 80 as part of a code for the recovery of VAT, which was exhaustive and which excluded other remedies. So at least so far as concerns the VAT itself, there is authority in this court that Section 80 provides the sole means by which VAT may be recovered. Taking that as the introduction, the Commissioner's submission on this is that Section 78 and Section 80 must be construed together. If those two sections are looked at together, the result is a single and exclusive scheme, both for the recovery of VAT that is not due, and also for payment of interest on that overpaid VAT. In my submission, the approach taken by Littlewoods on this point seeks to isolate the Section 78.1 reservation, those words at the end of Section 78.1, from their context. And the consequence of that is that, in fact, the Section 78 obligation to pay interest would never arise at all. Now, I say that because going back to Section 78, as I said already, Section 78 introduces an obligation on the commissioners to pay interest in specific circumstances. If one reads the reservation as including reference to any available common law claim, one can see that in all cases there would be available to a taxpayer some form of common law claim for the recovery of an amount equivalent to interest. And in those circumstances, the approach that Littlewoods take in this appeal to the Section 78.1 reservation, for all practical purposes, may well render redundant the remaining provisions of Section 78 and the obligation to pay interest under that section. Obviously, an important plank of this first submission, that Sections 78 and 80 need to be read together, is the provision within Section 80, Section 80 subsection 7, that excludes other claims for repayment of overpaid VAT. My Lord, the approach the Commissioners invite you to take on this is that absent The approach the Commission invites you to take is that one needs to look at Section 80 and Section 78 together, because the effect of the Section 80 subsection 7 exclusion is, in practice, to exclude not simply a restitution claim for the recovery of the principal amount, but also any claim in restitution directed towards the use value of the money. The reason for that is that, as a matter of legal analysis, even if on a restitution claim, such as the claims in these proceedings, the claimant does not need to seek repayment of the principal amount because the principal has already been repaid, nevertheless, the restitution cause of action rests on the initial mistaken overpayment. That overpayment and the way in which it can be recovered is addressed by Section 80 subsection 7. And the consequence of that exclusion, when one reads Section 80 and Section 78 together, is to exclude the possibility of a common law cause of action directed towards recovery of the use value of the money.
I wonder if one way of looking at it might be to say this, that the statute treats the taxpayer as having a claim for the repayment of a principal amount of overpaid tax under Section 80 and an ancillary claim for interest on that amount under Section 78, whereas the common law approach to unjust enrichment wouldn't be to separate the two elements in that way, but simply to ask by how much was the revenue enriched and make an order for the repayment of effectively the deprivation of the revenue of the amount by which it was enriched, which would be a global figure, inclusive of both the amount of the overpayment and also the value of the use of that of those payments for the time that they were available to the revenue.
Well, quite so. And if one looks at it in that way, if one approaches matters in that way, one can see that if one takes out of the common law equation the ability to recover the sum that was overpaid, the mistaken payment, one thereby pulls out of the common law equation the very thing that generates liability when it comes to reversal of the overall benefit. So far as the common law claim is concerned, if there is to be a claim in restitution, there must have been, on this analysis, a mistaken overpayment.
So the words at the end of 78(1), if and to the extent that they're not be liable to do so apart from this section, when would those words apply?
Well, each of the courts, the courts below, my lord, have each reached the conclusion that those words of reservation are directed towards other statutory interest claims.
Such as?
Any interest that may be payable under Section 35 A of the Supreme Court Act. Also, sums that may be payable in respect of claims under Section 84(8) of the VAT Act. My lord, in this regard,
Sums under 35A, that's judgment debt.
Yes.
That wouldn't be money on that amount. It would be the amount on the judgment debt, wouldn't it? Wouldn't be, because the overpaid tax is, as it were, converted into a judgment debt. So interest wouldn't arise on that, even under Section 78.
Well, I think, can I take you to the reasoning of the...
I suppose that there could have been an agreement with the revenue. If you pay this money and we have to pay it back, we'll pay you 10% per annum or something. There could have been
Yes, but none of the courts below have addressed the meaning of the reservation in that way. They have all...
I know they haven't, but I'm asking.
Oh, sorry. Well, my lord, with respect, my submission is they dealt with it in the way that they did and were correct to do so. Right. I think it would help, rather than for me to continue on this, if I simply took you to the passages in the judgments that have considered this. My lord, firstly, it's Mr. Justice Voss in this litigation, which is volume 8, tab 75, my lord. And within that tab, if you go to paragraph 60 of the judgment, which is at page 2936. My lord, just for your note, Mr. Justice Voss's reasoning on issue 1 starts at paragraph 45 at page 2932. And you'll
2932.
Yes, and you will see in the course of that, he refers, amongst other matters, to Mr. Justice Henderson's judgment in the Chalk case, which I will take you to next.
Okay.
Paragraph 60. Mr. Justice Voss said this: what then is the proper construction of the exclusionary words? It seems to me that despite their generality, they must be taken to be referring only to other statutory provisions under which the commissioners would be liable to pay interest. Any other construction would make a nonsense of the provision. Parliament must have been saying that in cases covered by sections 80 and 78, this is the only regime that applies. See section 80, subsection 2 and 7. But insofar as interest is concerned, other statutory provisions still subsist in the case, for example, of legal proceedings, section 35A, tribunal proceedings, section 85A. If the exclusionary words in section 78 were construed as referring to any common law restitution claims, they would, in the words of the tests expounded by Lord Mance and Lady Justice Arden, be inconsistent with the core provisions in sections 78 and 80. I realise that I've turned the test around, but inconsistency works the same both ways. The type of inconsistency involved is precisely that referred to by Lady Justice Arden, namely the statutory remedy has some restriction in it which reflects some policy rule of the statute which is a cardinal feature of the statute. Here, the restriction in the statute is the limitation to the claims delimited by sections 80 and 78. So far as interest is concerned, that is a restriction to simple interest, and at the applicable rates and for the applicable periods. The limitation does indeed reflect the policy of the statute, which was to limit claimants to the interest specified, at least in the circumstances specifically mentioned in the statute. That was the approach taken by Mr. Justice Voss. Mr. Justice Henderson's reasoning on the same issue when it came up in different litigation, the case of Chalk. My lord, that's also, sorry, that's within volume 7.
Sorry, just before we leave that, can I just ask,
I'm sorry.
Claims can be brought under section 80 for payment. Can they be brought in a forum which would be awarding statutory interest on the amount awarded?
If they're brought within the tribunal, my lord, that would be the section 80.
85A.
85A provision that Mr. Justice Voss refers to. I think he's referring to section 35A simply to cover the possibility that there might be some claims that could be brought outside the scope of the VAT tribunal.
Yes. So that would be an example of interest being payable on the amount due under section 80, yes. Where the interest was regulated by a different statutory provision from section 78.
My Lord, Mr. Justice Henderson in Chalk, which is volume 7, tab 60. Volume 6, my Lord, I apologise. Tab 50. And here, my Lord, paragraph 73 in the judgment, which is at page 2340, towards the bottom of the page.
Right.
And again, my Lord, again, just for your note, Justice Henderson's treatment of this issue starts a few pages back, paragraph 57, page 2335.
Right.
So paragraph 73, he says this: the true analysis in my judgment is that section 78 provides a limited and subject to one point exhaustive right in respect of payments due from the commissioners to taxpayers. The one exception lies, of course, in the words if and to the extent they would not be able to do so, i.e. pay interest apart from this section. The question is what source or sources of liability to pay interest, apart from section 78, are contemplated by those words. Read in the context of the statutory scheme, I consider that the words must be construed as referring only to other liabilities to pay interest which are found in statute, and not as extending to any liability to pay interest at common law, which the taxpayer might otherwise be able to establish. In particular, there has always been a power for the Value-Added Tax and Duties Tribunal to award interest at such rate as it may determine on amounts of overpaid VAT that it orders to be repaid, or on unpaid amounts due to the taxpayer in respect of input tax. This was first enacted in section 40, subsection 4 of the Finance Act 1972, re-enacted as in VAT Act 1983, and is now found in section 84(8) of the VAT Act 1994. The effect of the relevant wording in section 78(1) is to give priority to any interest awarded by the tribunal and to prevent double recovery of interest by the taxpayer. And this is for those reasons I conclude as a matter of domestic law, the statutory scheme for the recovery of overpaid VAT in section 80 is an exhaustive one, and that interest may only be recovered on a repayment of overpaid VAT by the commissioners if it is awarded by the tribunal or pursuant to section 78. The exclusion in section 80 subsection 7 of any liability to repay overpaid VAT, save as provided for by section 80, necessarily prevents the recovery of any interest on the overpaid VAT except where section 78 or some other statutory provision provides an entitlement to such interest. In particular, there is no room for a common law right to recover compound interest by way of restitution to coexist with the enclosed and carefully delimited statutory scheme. So, my Lord, that is the way in which the judges at first instance, or two judges at first instance, addressed the significance of the Section 78 reservation. And, my Lord, I say that they were correct to do so in that way. Returning to the submissions the commissioners make on this appeal, as I said, the first is that the prohibition in section 80, subsection 7, is significant and determinative because the prohibition against recovery of principal of overpaid VAT by any means other than a statutory claim has the effect that the common law claim, the restitution claim, which might be put in terms of, by reason of, the mistaken payment of the principal, the claimant is entitled to restitution, including the use value of that claim. Claim put in that way is simply no longer available to a claimant because of the effect of section 80, subsection 7. My Lord, you will have seen from paragraph 7 of the Commissioner's Skirton argument here that we refer to the judgments of the House of Lords in Sempra in support of the contention that it is simply not possible, as a matter of the common law claim, to distinguish the initial mistaken overpayment from recovery thereafter of benefits accruing by reason of that overpayment. My Lord, Sempra Metals is in volume 11 of the authorities at tab 88. The report starts at 3581. And my Lord, firstly, the speech of Lord Nichols. Lord Nichols' speech starts at page 3612. If I could ask you to go to the passage on 3622 that commences under the heading Interest, Benefits and Restitution.
Yeah. Yes.
My Lord, paragraph, the court will recall that in the circumstances of that case, there had been an initial payment of advance corporation tax. By the time the claim the payment of that tax was contrary to EU law. By the time the claim for repayment had been made, the due date for payment of mainstream corporation tax had arisen, with the consequence that the amount paid as advance corporation tax was in any event lawfully due as mainstream corporation tax. So the proceedings were only in relation to the use value of the money during the period between the date on which advance corporation tax became payable and the date on which mainstream corporation tax became payable. Paragraph 102, Lord Nichols' speech, paragraph 101, he's introduced the two restitution claims, and 102, he says this: in principle, this claim is unanswerable. The benefits transferred by Sempra to the Inland Revenue comprised, in short, 1, the amounts of tax paid to the Inland Revenue, and consequentially, 2, the opportunity for the Inland Revenue, or the government of which the Inland Revenue is the department, to use this money for the period of prematurity. The Inland Revenue was enriched by the latter head in addition to the former. The payment of ACT was the equivalent of a massive interest-free loan. Restitution, if it is to be complete, must encompass both heads. Restitution by the revenue requires 1, repayment of the amounts of tax paid prematurely. This claim became spent once the set-off occurred. And 2, payment for having the use of the money for the period of prematurity. Lord Nichols clearly recognises that the use value of the money was part of the benefit transferred, but that in no way alters the fact that absent the initial payment of advance corporation tax, no restitution claim would have existed for Sempra. My Lord, I note at this stage that in their submissions, Littlewoods place significant reliance on the statement of Lord Hope, or a statement by Lord Hope in his judgment in the same judgment at paragraph 25. If I could take you back to that. Lord Hope's speech starts at page 3596. Paragraph 25 is 3604, and this is the passage that Littlewoods place reliance on. He says, there is no need to pursue these arguments any further in this case. The question whether there is an unjust factor has already been settled. As the European Court of Justice has explained, there was no legal ground for the retention of the enrichment. The unjust enrichment principle supports the freestanding cause of action to recover interest, which is the measure of enrichment. It has not been suggested that a restitutionary award by way of interest would give rise to injustice, so long as it was appropriately calculated. Now, my Lord, that's the passage relied on. In my submission, one needs to go slightly further back into Lord Hope's speech, at least until paragraph 22 on the previous page, page 3603.
Thank you.
If one reads the run of paragraphs from paragraph 22 through to and including 25, it is clear, in my submission, that the restitution claim exists, so far as Lord Hope is concerned, only by reason of the fact that the initial overpayment was made. And one sees that, for example, paragraph 22, Lord Hope's starting point is the speech of Lord Gough in Kleinworth Benson. Similarly, paragraph 23, which is addressing the question of positive reasons for restitution. Again, the factor that generates the cause of action on the facts of that particular case was the initial overpayment or the initial wrongful payment of advance corporation tax. So taking those points together, the relevance of section 80 subsection 7, I say, is plain. It excludes the common law, any common law claim in relation to the overpaid VAT, but in doing that, it also rules out any restitution claim under which a taxpayer sought to recover the use value of the same overpaid VAT. The fact that the measure of restitution that is sought in these proceedings by Littlewoods only relates to the use value of the money, I say simply does not change that position at all, because the prohibition at subsection 7 in section 80 removes the basis for Littlewoods restitution claims, in that it says that the question of overpaid VAT can only be addressed through the statutory scheme. Now, my Lord, this was also the view taken by Mr. Justice Henderson in Chalk. And if I could ask you to go back to that judgment, that is back in volume 6 of the authorities at tab 50.
Right.
6.
Sorry, my Lord, 59 is the tab.
59, sorry.
Yes, 59.
Yes, of course, we looked at this. Yeah.
The material passage here, Mr. Justice Henderson's judgment, paragraph 6, starting at paragraph 69 at page 2339, and it's the run of paragraphs through to and including paragraph 72. My Lord, could I invite you just to read those paragraphs, please?
Yes.
So, my Lord, just to highlight a couple of points. Firstly, paragraph 7, Mr. Justice Henderson acceptance that the interest claimed could only be interest in respect of the VAT that was overpaid, and without that original...
Paragraph 70.
7T, my Lord, yes, 70. It's just between B and C. That point that the interest can only be interest on the VAT that was overpaid, and this is the further point between B and C, that without that original overpayment there would have been no unjust enrichment. And
what Sam said is wrong, isn't it? The claimants aren't claiming for loss. I mean, that mistakes the nature of an unjust enrichment claim. They're not claiming for their compensation for their loss. Their claim is based on the value of a benefit which was received by the revenue.
Sorry.
But just opposite C.
I think they talk about loss of use.
Yes, for loss of use of which they can make a claim.
Well, my Lord, yes, that is a point which, of course, is a matter of central relevance when one gets to issue 6A and 6B.
And the same point is made just below E. Well, so it's put the same way. That it's a claim for interest can be maintained whether it's claimed as damages for late payment or by way of restitution for loss of use. Well, you don't get restitution of a loss. You get restitution of somebody else's benefit.
Yes, I think at that stage, in fairness to the judge, these are words I never like to say, but in fairness to the judge, I think he was using the loss of use, the reference to loss of use, simply as a shorthand for the identification of the restitution benefit. Yeah. Though, my Lord, of course, as you will have noted, when one gets to issue 6A and 6B in this case, the nature of the restitution measure of recovery is something that is at the focus of the Commissioner's submissions. But for present purposes, the key point in my submission is the way in which Mr. Justice Henderson recognises a direct link between the initial overpayment, the thing that at common law generates the restitution liability, and the availability of a common law remedy in respect of loss of use or recovery of benefit from a defendant who has had the use value of money that has been overpaid. Paragraph 71, you have noted that Mr. Justice Henderson then addresses the timing issue. Is this analysis changed by the fact that, say, in the circumstances of the present case, the principal, the overpayments, have already been repaid, and what is pursued is a claim in respect of the use value of that money? And Mr. Justice Henderson, again, is very clear that timing point makes no difference at all, because it does not alter the fact that the root of the common law claim is the initial overpayment of VAT. And then at paragraph 72, he looks at matters from a slightly different perspective. He looks at it from the perspective of the detailed regime that is established by Section 78, and states the conclusion that in those circumstances, reading the words at the end of Section 78(1) in the way that in these proceedings Littlewoods invite you to read them would nothing less than subvert the entirety of that statutory scheme under which interest is available and the rate at which interest is paid. My Lord, that's the end of the first part of the Commissioner's submission on issue 1. The second way in which we say the point can be put is set out from paragraph 9 of the supplementary skeleton argument, and it's by reference to the principle of construction in Monroe and Revenue and Customs. My Lord, that judgment is in volume 9 of the authorities.
Yep.
And at tab 70.
Tab,
79, my Lord.
thank you. Yes.
And the relevant passage is the starting point is paragraph 22 of the judgment of Lady Justice Arden. My Lord, that is at page 3214. And there she sets out what she means by the notion of inconsistent in terms of construction of legislation. She says at paragraph 22, in my judgment, the authorities give clear guidance that if Parliament creates a right which is inconsistent with a right given by common law, the latter is displaced. By inconsistent, I mean that the statutory remedy has some restriction in it which reflects some policy rule of statute which is a cardinal feature of the statute. In those circumstances, the likely implication of the statute in the absence of contrary provision is that the statutory remedy is an exclusive one. My Lord, based on that principle, my submission is that it's readily apparent in this case that sections 80 and 78 are intended to put into practice an integrated and regulated regime for repayments of overpaid VAT and payments of interest on that overpaid VAT. And again, it's a different way of looking at the first submission that I made to you. Section 80 provides the right to repayment, and then section 78 provides, consequent on that, an obligation on the commissioners to pay interest on the sum overpaid. In those circumstances, I say it would be entirely inconsistent in the sense set out by Lady Justice Arden in Monroe to permit a claim for restitution for the use value of overpaid VAT. It would, to put it mildly, be distinctly odd if section 80 subsection 7 stood as an impenetrable barrier to the claim for recovery of the VAT, but nevertheless a common law restitution claim was permitted in respect of the use value of the very same overpayment. And, my Lord, we seek to support that submission, paragraph 12 of the supplementary skeleton, by setting out in that paragraph various features of the statutory scheme within section 80 and section 78.
Would it mean In the investment trust company's case, we considered Section 80 in some detail.
Yes.
And its relationship to the common law. And something we focused on there was the shortened limitation period,
Yes.
which there is in Section 80. And it just occurs to me to wonder, is the implication of Mr. Rabinowitz's argument that albeit the limitation period under Section 80 would bar a claim for repayment of the tax, you would still be able to reclaim compound interest on the tax because that wouldn't be barred by Section 80 and it wouldn't be barred by it wouldn't be excluded by Section 78 either.
Well, precisely so. That must be a consequence of his argument. We make the point about time limits at subsection 2 of subparagraph 2 of paragraph 12 of our supplementary skeleton. Because again, it must be the logic. If Mr. Rabinowitz's submission starts from the premise that a restitution claim in relation to the use value of money can continue to exist entirely independently of the initial overpayment, the mistaken payment that generates the liability, it must follow from that that a statutory limitation period would simply not bite on his restitution claim for the use value of the money. So we would have a situation whereby repayment of principal would now be subject to the limitation period within the Act, but any claim for interest could be made outside Section 78 and thereby the limitation period would be entirely avoided. It would be a striking scenario.
Can I ask you this? In that judgment, we referred to the Law Commission report which preceded the introduction of Section 80.
Right.
And my recollection is that one of the themes of the chapter in the report dealing with the repayment of overpaid tax was the importance of avoiding disruption of public finances.
Yes.
It occurs to me it might be helpful for us to have that if there's anything in it which might be relevant to this case.
Well, very well. I will ensure that.
It might be worth at least looking at it.
Yes, my lord, certainly yes. My lord, turning to the next part of this submission, and this is the response to what Littlewoods say at paragraphs 51 and 52 of their written case for this appeal. That contention, in summary, is that Section 78 and Section 80 need not be regarded as parts of a single code because, firstly, Section 78 interest is not limited to circumstances of a Section 80 repayment. Again, you will recall that Section 78 1A is the part of Section 78 that deals specifically with the question of Section 80 repayments. There are then other further subparagraphs within Section 78.1 that deal with other matters. And secondly, because Sections 78 and 80 were introduced independently of each other. Section 78 came in by way of the Finance Act 1991. Section 80 had come in by way of the Finance Act 1989. Dealing with the second point first, the timing of the introduction of the two sections, in my submission, that simply has no bearing on how Sections 78 and 80 should now be construed. They both now sit together within the Act. They are, in my submission, clearly part of a package, and in those circumstances, the timing of their enactment is simply not a material consideration. As to the first point, that Section 78 is not limited to interest only on Section 80 overpayments, but also deals with interest payments in other circumstances. My response is that it's really, well, it doesn't matter. The fact that Section 78 may address situations going beyond Section 80 does not detract at all from the submission that the part of Section 78, Section 78.1a, that does address interest on payments under Section 80 should be regarded as forming part of a single coherent code, together with that part of Section 80 that deals with overpayments of VAT. My Lord, the third aspect of the submission, and again, as with many construction submissions, all aspects tend to converge ultimately, but the third aspect is under the heading coherent construction of Section 78. And the starting point for this is the point recognised by Mr. Justice Voss in his judgment, and this is paragraph 60, that the approach that Littlewoods take to the reservation within Section 78.1 would make a nonsense of Section 78 itself. If I could ask you to go back to Mr. Justice Voss's judgment.
This is all set out in paragraph 18 of your skeleton, isn't it?
Yes, it is. It's that paragraph. If you're content to take it from there, I'll just give you the reference. It's volume 8, tab 75 for Mr. Justice Voss's judgment. And, my Lord, the page number there is 2936. And the practical point here is that if Littlewoods are correct in their interpretation of the Section 78 reservation, the duty to pay Section 78 interest would never actually arise in any case where a person was entitled to a repayment of overpaid VAT, because, on Littlewoods' analysis, the taxpayer would always have a common law claim for interest against the commissioners, either a mistake-based restitution claim or a Woolwich-type restitution claim. Again, important to have well in mind that the way in which Section 78 is formulated is that it is formulated as an obligation to pay interest in specified circumstances. Hence, the conclusion that Littlewoods' submission results in a situation where that obligation to pay interest would never arise. It doesn't matter whether or not the taxpayer might choose to pursue Section 78 rather than the common law claim. As a matter of statutory construction, the Section 78 duty to pay interest would simply never arise, regardless of the taxpayer's choice, because in all circumstances, on Littlewoods' analysis, that taxpayer would have an alternative route by which interest could be claimed, the restitution claim. Now, in their written case, as I read it, Littlewoods do not dispute this point. Their contention is simply that it's not a point that matters. They say it's the result of the fact that a claim in restitution for mistake was recognised only in 1999, some years after Section 78 was first enacted. And so Littlewoods say, well, the fact that our construction makes a nonsense of Section 78 is simply the consequence of a development in the common law. My Lord, my response to that is that it's simply a non sequitur. The submission as made by Littlewoods seems to accept that at the point it was first enacted, Section 78 and the reservation within it, or rather the reservation within Section 78, would have been understood to refer only to other statutory claims for interest. Now, if that is so, the meaning of those words is not altered by the subsequent recognition of a common law restitution claim. So in those circumstances, that point only goes to support the conclusion reached both by Mr. Justice Voss in this case and Mr. Justice Henderson in Chalk, that the words of reservation are to be understood as referring to other statutory claims for interest. And you will have noted at paragraph 16 of the skeleton argument that we refer there to other statutory claims, as you have already seen referred to in those two judgments. So, my lord, those three strands together, firstly, the true role of section 80, subsection 7. Secondly, the need to avoid inconsistency between the construction of the statutory scheme and common law claims. And thirdly, the practical consequence if Littlewood's submission as to the meaning of the section 78.1 reservation is correct. Those three strands in my submission provide adequate support for the conclusion reached by all courts below, that the effect of section 78 and section 80 construed on the basis of ordinary principles of statutory construction is to prohibit restitution claims in this case based on overpaid VAT, notwithstanding that in those claims what is sought is recovery of the use value of the money that was overpaid. So, my lord, that's the submission in relation to issue 1. I won't at this stage address issue 3A. That will arise if the court is against me on my submission on issue 2. If the court is against me on my submission on issue 1, well, issue 3A still won't arise, because the consequence of a finding against the commissioners on issue 1 would simply be that there was no statutory prohibition preventing the restitution claims, and everything else would have been an interesting diversion, save for issue 6A, which would go to the measure of the restitution claims that Littlewoods were on this analysis permitted to pursue. But I'll leave issue 3A to deal with together with issue 3B in the event that the court concludes in my favour on issue 1 but against me on issue 2. My lord, if I may, I will turn now to issue 2. Plainly, at the centre of this issue is the judgment of the Court of Justice in the reference that's already been made in these proceedings. My lord, that judgment is in volume 3 at tab 34 and starts at page 1403. My lord, at the heart of that judgment, obviously, is paragraph 29.
Yes.
And that paragraph is at page 1425.
Yes.
And in particular, it's the statement by the court that the calculation of interest should not lead to depriving the taxpayer of an adequate indemnity for the loss occasioned through the undue payment of VAT. Now, by this point in its judgment, the court had done two things. Firstly, at paragraph 26, earlier on that page, it had stated that it is a principle of EU law, arising from the court's previous case law, that there is an obligation to repay tax levied in breach of EU law with interest. And that's the paragraph 26 statement. The second thing the court had done, paragraphs 27 to 28, is that it had identified the content of the obligation to pay interest by reference to the EU law principles of effectiveness and equivalence. And it's only then that at paragraph 29, the court described the obligation to pay interest by reference to this notion of an adequate indemnity for the loss occasioned through undue payment of VAT. Now, although those words in paragraph 29 may be at the centre of the argument, my submission is that it is important and indeed necessary to try and make sense of the judgment looked at in the round. And that looked at in the round, one cannot proceed straight from the reference to adequate indemnity straight to the conclusion that what is required for all practical purposes is full compensation. And, my Lord, I make a number of points in support of that overall submission. The first, and this is simply by reference to the language used, and so I appreciate it's a point, but it's not going to be necessarily the point of greatest weight. But I'll start with it. I've got to start somewhere. There's nothing determinative about the fact that the word indemnity is used at paragraph 29.
Yep.
And this was a matter pointed out by Mr. Justice Henderson in the course of his judgment. Can I take you back to that? I'd invite you to leave the Court of Justice's judgment in Littlewoods open if you're using paper, as I'll be coming back to it. But Mr. Justice Henderson's judgment is volume 9, tab 77. At this point, it's paragraph 267, which is page 3077.
Yes.
And he says there, speaking by reference to two cases that had followed Littlewoods in the Court of Justice, it will be noticed that in paragraph 26 of Irami, reference is made to, quote, adequate compensation for the loss sustained by the taxpayer, whereas the phrase used in paragraph 29 of Littlewoods is an adequate indemnity. Nothing turns on this apparent distinction, however, because in each case, the original French text of the judgment uses the same, well, I'm not going to strangle French, but one can read the words there. And my Lord, for your note, should you want it, Irami is in volume 3, tab 32. It starts at page 1359. The particular paragraph, paragraph 26, that Mr. Justice Henderson refers to there is at page 1371.
1371.
1371, that's paragraph 26, where one sees the same words as used in French, translated there as adequate compensation. Now,
I mean, there's at least in the English translation, there's rather loose use of language.
yeah,
And they speak of reimbursement in several places.
yes.
But here they're talking about compensation for loss, which is, at least in our legal systems, a quite different concept.
Well, indeed, my Lord, and it perhaps highlights the fact that, at least in terms of the way in which the Court of Justice sees the San Giorgio right, it appears now to be a right that includes some elements of some things we would identify as restoration of benefit, and elements of other matters that we would regard as compensation for loss. The court itself not being obviously particularly concerned about the way in which member states might classify the cause of action within their own legal systems. But nevertheless, I take the point that the language used by the court, if one tries to look at this simply linguistically, is rather swinging from pole to pole.
Yes, I'm rather wondering to what extent the content of the taxpayer's right is a matter of EU law, and to what extent it's a matter of domestic law.
Well, I'll come to this very shortly, but my submission is that the content of the right, well, it's been identified as an EU law right. To that extent, EU law must say something about the content of the right. And what the court says about that is simply by reference to the principles of equivalence and effectiveness, which are, as it were, well-known backstop principles. And so that takes one to the position that the content of the right as a matter of EU law is not precisely prescribed, but rather the content is left for member states to identify in accordance with their own national rules, subject to the long stop boundaries that the principles of effectiveness and equivalence provide. But I'll come to that in a moment. Just sticking with language for a moment, the point that I make is that if it's regarded as important to look for a clue as to the derivation of the words used in paragraph 29 of the judgment, there's no need to look further than the observations made in that case by the EU Commission. Those observations are cited in the course of the Advocate General's opinion. If you go back to that case, which is volume 3, tab 34, this time in the Advocate General's opinion. It's paragraph 11, which is at page 1409.
Thank you.
Advocate General says there, in the view of the Commission, the first, second and third questions should be answered to the effect that where a taxable person has overpaid VAT, which was collected by the member state contrary to the requirements of EU VAT legislation, a remedy which provides only for reimbursement of the principal sums overpaid and simple interest on those sums is compatible with EU law insofar as that remedy provides adequate restitution or compensation for the loss of the use of the money, and insofar as no more generous remedy is available as a matter of national law in relation to other taxes. And so significant not only that if one needs to look for the derivation of the language, that's an obvious starting point, but also significant that the Commission's observation is made in the context of an argument or a representation to the effect that an approach based on simple interest is capable of being consistent with EU law, subject to the requirements of effectiveness and equivalence. My second point, and perhaps a more important point, is they return to paragraphs 27 and 28 of the judgment of the court. My Lord, those are the paragraphs that are back on page 1425. And the fact that in those paragraphs, the court identifies the substance of the obligation to pay interest as being set by the principles of effectiveness and equivalence. And I say it's clear that this is a description of the substance of the right, not simply the means by which the right can be asserted, because the court refers in terms both to the rate of interest and to the method of calculation, simple or compound. And so clearly this is paragraph 27. Clearly there the court is addressing the substance of the right, not merely the means by which it can be realised. That is significant because, as I've already indicated, the sole purpose of the effectiveness and equivalence principles is to establish minimum standards across EU member states. My submission is that the necessary consequence of the approach set out by the court at paragraph 27 as to the substance of the obligation to pay interest is that the content of that obligation is not to be and will not be the same across all member states. So not just a question of the means by which interest is calculated, but also in respect of the ends, what interest is actually payable. That will vary. It is anticipated that will vary from member state to member state. Indeed, because the whole point of the principles of equivalence and effectiveness is that they are not principles that require a harmonisation of approach. Just to support that point, the fact that there is no such harmonisation is equally clear from the way in which the court at paragraph 27 describes the notions of equivalence and effectiveness. It describes them using the same language that the court has used on numerous occasions over the years to describe precisely those propositions. And so there's no departure in terms of the matter that the court is getting at when it uses the language that it does in that paragraph.
Was there evidence, or are we told how this is dealt with in other states? I see France and Germany were intervening.
I think that there was evidence before the court as to how matters were addressed in some member states. I think this is referred to in the Advocate General's opinion. Well, perhaps I can come back.
It may not matter.
I'll come back
It'd be
to when I have
interesting to know whether we're out on a limb on this or.
No, I think.
There's evidence. They looked at 13 or so states and said, other than Sweden,
Yes.
simple interest alone was paid. I recall a reference to that.
My recollection was that Sweden was out on a limb in that it provided for compound interest. The other states for which there was information took a simple interest.
Does the Attorney General grapple with that?
I think she does, my lord. What I will do perhaps is identify the paragraph over the lunch break, and so I can give it to you immediately after lunch, rather than spending time searching now. But that is my recollection of the position in terms of the evidence before the
I mean, it was clear from the way the questions were put to the court that the issue of simple versus compound was very much in play, and indeed was one of the central issues in play, and the court would have had to grapple with that.
Yes.
But in the end, they say, well, it's back to the national court.
Yes, well, quite so. You saw the way in which Mr. Justice Voss set up the reference questions, which were effectively a series of if not one, C2, and so on. And you're right, the court did not address the questions in that order or in the way that Mr. Justice Voss had perhaps hoped that it would, which no doubt is one of the reasons why there is a debate now as to what the court actually meant when it gave the answer that it did. But my submission on this is that the focus of the court's description of the content of the right is these notions of effectiveness and equivalence.
Yes, I mean, you picked out paragraph 29, which talks about adequate indemnity, but that's simply leading on to paragraph 31, where the key issues are effectiveness and equivalence, which of course what are picked up then in the ruling.
Well, quite so. One has to try to get a sense of the judgment in the round. I say that if you start from effectiveness and equivalence, that explains why at paragraph 30 the court talks in terms of the national court having regard to all the circumstances of the case. Because, again, if the EU law right to interest had a fixed content, if it was simply compensation equivalent to the use value of the money or the loss of use value of the money, there would be no need to have regard to all the circumstances of the case. You'd only have to have regard to one circumstance, which is what is the loss that the taxpayer has suffered. And it also, the reference to effectiveness and equivalence, also explains why it is later in paragraph 30 the court picks out the matters that it does. That is to say, looks at not, it highlights the amount of the sum that was paid by way of interest. It highlights the fact that the sum paid by way of interest exceeded the principal amount by a significant percentage. And it also highlights the fact that the interest payment arose in respect of a claim for principal that stretched back over 30 years. Now, in this appeal, Littlewoods rely heavily on the fact that the statutory interest paid does not reflect the use value of the overpaid principal sums over the 30 years covered by the claim. That's a central part of Littlewood's contention when it comes to its explanation of the phrase adequate indemnity. But in my submission, the court's reference to the 30-year period of the claims for principal has a different significance. Rather, in my submission, what the point the court is making is that it is striking that any claim is able to stretch back that far without being curtailed by some form of limitation period, and a limitation period that would itself be entirely consistent with the notion of an effective remedy under EU law. And so, in the present context, the reference to adequate in front of the word indemnity in paragraph 29 takes account of the duration of the claim for repayment of principal. And so what comes from paragraph 30 is not that there is some notion of a relationship of straight line proportionality between the period of the overpayment and the extent of the obligation to pay interest, but instead the suggestion that where under the laws of a member state a claim for principal can reach back over a very long period, such as the 30 years here, the EU law obligation to interest does not entail such a straight line relationship, but rather that the EU law obligation is satisfied where the interest paid is of itself a substantial amount. hence the court's reference to the amount paid and the percentage by which the amount paid in interest exceeded the amount of principal that had been overpaid. Now, my Lord, my submission is that this conclusion as to the way in which one should approach the court's reference to the period over which the overpayments were made is entirely consistent with the court's starting point, that the content of the right is driven by the principles of effectiveness and equivalence, because at least taking the principle of effectiveness first, that principle is sufficiently broad to take into account a notion of fair balance between individual interest, the taxpayer's interest, and the collective interest. Some notion that there is a coherent approach to public finances. And the same conclusion is also capable of explaining why the court refers to the matters that it does at paragraph 30 of its judgment. Now, my Lord, the submission that the principle of effectiveness includes consideration, or can include consideration of the notion of fair balance, is a submission that's supported by statements made by Advocate General Jacobs in the earlier case of Fantask. Could I invite you to turn to that, please? It's in volume 3 of the authorities at tab 29.
Yes.
Tab 29 starts at page 1225. My Lord, just by way of context, this case, the context of the case was a Danish tax on company registration and increases in capital of a company. And various questions were referred to the court concerning the consistency of that tax with an EC directive on indirect taxes on the raising of capital. As I say, there are a range of questions referred. Could I invite you to look at 2 of them? They're both on page 1233. It's question 6, and in particular question 7. So question 6 raised a question as to the compatibility with EU law, effectively of a settled practice defence. Question 7 is the one that's of particular importance for present purposes. Does community law make it impossible under national law for the authorities of a member state in cases of claims for recovery concerning charges made contrary to Directive 69335 to contend and establish that national limitation periods start to run from a time at which an unlawful implementation of Directive 69335 occurred? So the question there concerned the legitimacy of time limits in circumstances where a member state had failed properly to implement a directive. Advocate General Jacobs addresses this firstly from its paragraph 53 on page 1244. The heading there in the right-hand column, questions 6 and 7. So paragraph 53, he summarises the questions. And then at paragraph 54, he says the latter question, so question 7, is prompted by the court's ruling in Emmett, a case concerning the Equal Treatment Directive. In that case, Irish authorities failed to grant Mrs. Emmett equal benefits pursuant to the directive until 28 January 1988, although the directive should have been implemented by 23 December 1984. Mrs. Emmett instituted judicial review proceedings with a view to obtaining equal benefits from 23 December 1984. The Irish authorities objected she had failed to make her application within the 3-month period from the date when the grounds arose as required by Irish law. However, the court held, and then Advocate General Jacobs quotes, so long as a directive has not been properly transposed into national law, individuals are unable to ascertain the full extent of their rights. The state of uncertainty for individuals subsists even after the court has delivered a judgment, finding that the member state in question has not fulfilled its obligations under the directive. And even if the court has held that a particular provision or provisions of the directive are sufficiently precise and unconditional to be relied on before a national court, only the proper transposition of the directive will bring that state of uncertainty to an end, and it is only upon that transposition that the legal certainty which must exist if individuals are to be required to assert their rights is created. It follows that until such time as a directive has been properly transposed, a defaulting member state may not rely on an individual's delay in initiating proceedings against it in order to protect rights conferred upon him by the provisions of the directive, and that a period laid down by national law within which proceedings must be initiated cannot begin to run before that time. So that was the judgment in Emmett. And the Advocate General then went on. The Danish, French, Italian and United Kingdom governments consider the principle as formulated above is too broad, inasmuch as it has the effect of imposing limitless retrospective liability on member states. Norsk Hydro and Trig Baltica, Alka Forsikring and others, and the Commission contend the court should adhere to its ruling on Emmett so that the 5-year limitation period did not begin to run until 1st May 1992. The next sentence, they argue that to allow a member state to rely on time limits in such a case as the present would permit it to escape the consequences of its own unlawful conduct and discourage it from taking steps to remedy the defect in its rules. In what follows, I shall explain why I consider the government's criticisms of Emmett to be justified and show that a broad view of Emmett cannot in any event be reconciled with the court's subsequent case law. I shall, however, also show that in light of other developments in the court's case law and remedies in the national courts, the concerns which led the Commission to favour a broad view of Emmett can be accommodated in a coherent system of remedies, allowing a proper balance to be struck between the need for effective protection of community rights, including those under directives, and the principles of respect for national procedural autonomy and legal certainty. Against that background, I shall finally turn to the Danish rules in issue here. So that was the Advocate General's introduction to this. The particular passage in relation to certainty is from paragraph 68 at page 1249 through to and including paragraph 72 on the next page. My Lord, would the court be so kind as to read those paragraphs, please?
Which ones again?
68,
72.
72.
Yep. Sorry, 72, I didn't hear that, thank you.
Yes.
So, my Lord, I place particular emphasis on the comments at paragraph 69 of the opinion, and also ask you to note the examples given by the Advocate General in the paragraph that follows paragraph 70. To complete the picture, I must show you the judgment of the court as well. My Lord, the material part starts at page 1276.
Thank you. Question 7.
Question 7. So, from paragraph 42, please note that paragraph 48, in relation to the conclusion that ultimately was the same conclusion on question 7 as the Advocate General had reached in relation to the permissibility of reliance on time limits, paragraph 48, the court makes express reference to the principle of effectiveness. You see its language there talks about time limits rendering the realisation of rights virtually impossible or excessively difficult, which is the usual language the court uses to refer to the principle of effectiveness. And that was all in support of the conclusion ultimately reached by the court that there was no requirement under EU law for the commencement of a limitation period to be postponed pending proper implementation of a directive. Now, my Lord, I rely in particular on what's said by the Advocate General in that case for the proposition that the principle of effectiveness can, in an appropriate case, in appropriate circumstances, act as a limiting factor. That is the point being made by the Advocate General in this case. And I say that is a point that reads across to the way in which the court in Littlewoods saw the principle of effectiveness as operating, hence its reference to the matters that it refers to at paragraph 30. So looking at it, looking at the principle of effectiveness as a limiting factor, in this case, it is a reading that makes sense of those specific matters identified by the court at paragraph 30 of its judgment, and the overall instruction the court gives at paragraph 30 for the courts, for the national courts to have regard to all the circumstances of the case. So, my Lord, moving to my next point, this is by reference to the principle of equivalence. The submission is that the content, that the submission I make as to the content of the EU law obligation to pay interest is also supported by what the court in Littlewoods said at paragraph 31 of its judgment in relation to the principle of equivalence. So, my Lord, it's back to the judgment in Littlewoods, which is volume 3, tab 34, and paragraph 31 is at the bottom of page 1425.
Yes.
Now, in that paragraph, the court is content to restate again its well-known approach to the principle of equivalence. And that is to say that it is a principle of non-discrimination between claimants whose claims are based on EU law rights and claimants who bring claims in reliance on rights arising under national law, and that the principle of equivalence does not require a member state to make available to EU law-based claims its most favourable rules. Those are well-known statements that the court habitually makes on the principle of equivalence. If, in this case, the obligation to pay interest under EU law were, in all instances, an obligation simply to pay an amount equivalent to the loss of use value of the overpaid tax, the principle of equivalence would have no role to play at all. Both because the content of the EU law obligation to pay interest would be fixed by EU law, irrespective of the extent of any national law obligation to pay interest, and because the EU law obligation would be significantly more favourable than any right under English law in respect of statutory interest under the VAT legislation. So again, if one reads the content of the right in the fixed way that Littlewoods suggests you must read it, it simply does not sit with what the court says at paragraph 31 of its judgment on the principle of equivalence. All this comes back to the point that if the Court of Justice intended the content of the obligation to pay interest to be fixed in that way, the court would not have formulated the reasoning it has in the way that it did. My next submission is that the approach that the commissioners say you should take to the judgment in the reference in this case is entirely consistent with the two cases in the Court of Justice since Littlewoods. And one of those cases is Irami, which I'll come to now, and the other is the case of Zucker Fabric. My Lord, Irami is in volume 3 of the authorities at tab 32.
Yes. Thank you.
Slightly behind you, getting my own bundle out. Yes, so starting at page 1359, and the judgment starts at page 1367, my lord, bottom of the page. The context for this reference was a rule of Romanian law by which, where a sum had been overpaid, any payment of interest only ran between the date on which repayment was claimed and the date on which repayment was made. So no interest was payable with effect from the date of the initial payment, only from the time that a claim for repayment was made. The relevant part of the judgment is from paragraph 22, which starts at the bottom of page 1370. You'll see there reference there to paragraph 26 of the judgment in Littlewoods. And then at paragraphs, so paragraph 23, again is referring to autonomy on the part of member states by reference to paragraphs 27 and 28 of Littlewoods. Paragraph 24 refers to the principle of equivalence and says there's nothing before the court relevant to that on this reference. Then paragraph 25, it appears from the documents before the court that the system at issue in the main proceedings, which grants interest only from the day following the date of the claim for repayment of tax unduly levied, applies to all sums to be refunded from public funds, those levied in breach of EU law, as well as those levied in breach of national law. That is a matter, however, for the referring court to ascertain. As regards the principle of effectiveness, that principle requires, in a situation of repayment of a tax levied by a member state in breach of European Union law, that the national rules referring in particular to the calculation of interest which may be due should not lead to depriving the taxpayer of adequate compensation for the loss sustained through the undue payment of the tax. Reference to Littlewoods paragraph 25. In this case, it must be found that a system such as that in issue in the main proceedings, which limits interest to that accruing from the day following the date of claim for repayment of the tax unduly levied, does not meet that requirement. That loss depends inter alia on the duration of the unavailability of the sum unduly levied in breach of European law, and thus occurs in principle during the period between the date of the undue payment of the tax at issue and the date of the repayment thereof. In the light of the foregoing, the answer to the question referred is that European Union law must be interpreted as precluding a national system, such as that at issue in the main proceedings, which limits the interest granted on repayment of a tax levied in breach of European law to that accruing from the day following the date of the claim for repayment of the tax. So, significant there that for the court, this case did not raise a consider all the circumstances of the case situation. Rather, there was an in-principle problem identified with the national law, and that was that the availability of interest was not in respect of the period from date of payment to date of repayment. But, in my submission, there is nothing said by the court in Irimi that in any matter detracts from what the court in Littlewoods said at paragraph 27 to 30 of its judgment as regards the content of the EU law obligation to pay interest. So, in short, Irimi was dealing with a different problem where there was an in-principle difficulty with national law as regards the structure.
It doesn't really help one way or the other, does it?
Well, it's so far, the courts below have said it actually goes against me rather than for me. I'd be very happy with it doesn't have help or hinder, but I simply draw your attention to it to explain that it was dealing with a matter that was somewhat apart from the question of the content of the obligation to pay interest that the court was addressing in Littlewoods.
I suppose you could say that the problem there was effectiveness, because of the limit in the time from which interest ran.
Yes.
And when the court in the Littlewoods case was dealing with effectiveness, it drew attention to the matters raised in paragraph 30.
Indeed. And, my lord, just following from that, one can see that in this case, in Irimi, the court said in terms that national law that has this characteristic in terms of the period for which interest is payable is precluded by EU law. There was no question of the circumstances. So that was, as it were, a structural problem. But the court takes a very different approach in Littlewoods when it's dealing with the overall content of the right, so long as national law is focusing on the right period between date of...
And you might also say of the Irme case that while it sets up the principle that interest is due from the date of payment, elsewhere we know that limitation periods can be imposed, which would have the effect of undermining that principle.
Yes, yes, my lord, yes, quite so, yes, quite so, yes.
So what you would say we don't read too much into Irme?
No, exactly, and again suggests that the principle of effectiveness, again, is capable of having that limiting effect, which will produce different consequences from member state to member state. The other case, which I can deal with briefly before the lunch adjournment, is Zuckerfabric. My lord, that is in Authorities Volume 5 at tab 51. Tab 51 starts at page 2003. There were joined cases before the court on this occasion. The facts of the case, so far as they are relevant, are set out in the judgment. My lord, the judgment starts at 2029. And the facts are at between paragraphs 23 and 31, which start at page 2024. Put very shortly, there had been an overpayment of a EU levy by British Sugar to the Rural Payments Agency. The Rural Payments Agency had then accounted for the money it received to an EU institution. It turned out that the levy was contrary to EU law and so needed to be reversed. The question was whether when the Rural Payments Agency reversed the payment to British Sugar, it was required to pay it with interest or not. And in circumstances where, of course, the Rural Payments Agency itself had simply handed the money over to a third party and had not itself received interest when the transaction was reversed in that direction. So the reference question was question 4, and 4A at the bottom of 2035, does European law preclude a person in the position of the applicant from recovering interest on sums overpaid as a result of an invalid Commission regulation from the national authority competent to collect production levies in circumstances where the national authority competent to collect production levies is precluded from recovering interest on the corresponding sums repayable to it from the Commission? So that was the question for the court. The response is at paragraph 64 on page 2040. 64 refers to the fourth question. 65, where a member state has levied charges in breach of the rules of EU law, individuals are entitled to reimbursement not only of the tax unduly levied, but also of amounts paid to that state or retained by it which relate directly to the tax. That also includes losses constituted by the unavailability of sums of money as a result of tax being paid prematurely. So the references there include Littlewoods at paragraph 25. And paragraph 66 is the conclusion that therefore follows that the obligation on the member state is to repay with interest, and the position as between the national institution, the national authority, and the EU authority is immaterial to that conclusion. Put shortly, that was the question and that was the response in that case, and there is nothing in that that has any bearing on any issue in this appeal. And so far as the two cases that follow Littlewoods in the Court of Justice, follow Littlewoods in time, there is nothing in them that is inconsistent with the Commissioner's submission on issue 2 in this case. My Lord, if that's a convenient moment, I have a little more to say about this issue, but not too much to say.
Right. Well, I think we should resume again at 2 o'clock. We'll hear you then. Thank you very much. Court's now adjourned.